The next case is City of Akron versus Beasley. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Councilman, how long would you like to reserve for rebuttal?
3 minutes, please.
Thank you. I will be keeping track of that up here, and you also have that over there to, I guess, your left, to look up there. So when it gets down to the 3-minute marker on that top thing, your time will be up if you're paying attention to that. I'll try to let you know about a minute left in your time, just so you're aware of that.
Thank you.
The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up. Stay behind the podium if you would, please, because we're visually recording as well as audio recording, so we can make sure we give you both audio and visually. You should not use the name of any child, minor, or victim in your case. I don't know if that will be relevant in this matter, but if so, please make sure you have some designation such as the child or the victim or something like that. We read your briefs and are ready to proceed whenever you.
Thank you, Your Honors. May it please the Court. My name is Kendra Davitt. I'm the attorney for Cortez Beasley, who is sitting in the back. I'm accompanied by Mr. Grube from our office. And this case is about an overzealous prosecution where the City of Akron failed to provide sufficient admissible evidence to sustain Mr. Beasley's arrests and convictions for failure to disperse and driving within a single lane of traffic. The judgment should be reversed, the conviction should be vacated, and Mr. Beasley should be discharged. There were 4 elements of failure to disperse that the city failed to prove. The first is that the Akron Police Department ordered Mr. Beasley to disperse, that Mr. Beasley failed to knowingly follow that order, that there were 5 or more persons participating in any disorderly conduct at the time that he was ordered to disperse, and that he was participating in disorderly conduct under the statute. There was a substantial amount of evidence that law enforcement officers made announcements throughout the city throughout the night of the events in question. Lieutenant Whitmire led the mobile field force, which is similar to a SWAT unit, and he was exercising crowd control, so he was walking throughout the city over the course of the evening, and he explained the path that his team took and the different announcements that were made throughout the night. They used loudspeakers, their public address systems in the cruisers, and as he stated, word of mouth. There was video evidence played at trial, and that suggested that not all of these announcements could be heard, especially with the loudspeaker and the word of mouth. So Mr. Beasley was arrested later in the evening. At the time of his arrest, Sergeant Sinsley had seen him standing in the roadway and said he was blocking traffic. There's no evidence that Sergeant Sinsley or any other officer specifically told Mr. Beasley to disperse. Sergeant Sinsley specifically testified he had been told to leave the area. I mean, realistically, if you're dropped in the middle of the night, there's no way you're not going to understand that this is not good. But that's not the standard imposed by the statute, which is the high knowingly standard. And there's no evidence that Mr. Beasley had any actual knowledge of the order to disperse. The city tries to lead you to believe that he knowingly violated the statute because he committed the conduct. But this isn't a strict liability offense. It requires actual knowledge on his part that he was committing this crime. There are limited instances where constructive knowledge has been determined to be sufficient, but none of them would apply in this situation. Just because the scope of the area where the police were making the announcements is so large, and there were numerous people and they were not in a static place. They were spread throughout the city over the course of the evening. The city cites the KISS case, where a larger group of students was on a dean's yard and they were protesting, and there were 4 police cars making announcements on their PA to disperse. And the students argued that they weren't able to hear those announcements, but under the situation, they were in one small location. The court determined that you could infer knowledge on that situation. The other case that the state cites is Harker, which I believe took place at Kent State. It was a 2-block party, and the police walked up and down the street for an hour, repeating over and over that the students needed to disperse from this large block party. and they arrest and to go inside in that situation. And Parker was found on a porch, and because he had not gone inside, they arrested him. And in that situation, the court determined that there was sufficient notice because they had announced it for so long in such a small area repeatedly. But none of that is evident here. I mean, I'm not from Akron, but you have a very large downtown area, and this is happening throughout the city, I mean, right around where we are.
Then if there was a large city, Akron, Cleveland, or summer with a large riot, how would the police let people know? Other than by announcing over their loudspeaker as they've gone as best they can, let people know what's going on. What would you have them do?
I would have them do that, but I would also not have them arrest someone until they specifically tell that person to disperse in case they hadn't heard the announcement.
How do you do that in a riot with a lot of people active? How do you specifically get everyone to say, I'm sorry, sir, but you have to leave now, or you have to leave now? There's a riot going on, but they're trying to control.
Well, there were various situations throughout the evening, but at the time that Mr. Beasley was arrested, there were 4 people standing in traffic, which is what Sergeant Sinsley testified to.
If he had heard this an hour beforehand when there was a riot and didn't leave, would that be sufficient? Or would they have to come up with that specific incident again, say, I'm sorry, you 4 folks in the road, you need to disperse?
I would say that you would have to give him notice again.
So once he received the notice, a person received the notice in that instance, you would say they still have to be noticed every time before they arrest somebody, even though they heard it an hour ago.
Well, how would you know that he heard it an hour ago is the problem. What if he just showed up? What if
Well, that is difficult in the statute, is how does someone know someone heard the warning in the first place? You know, what's in these other cases you saw? There's some difficulty in actually proving that, so how do we know that they knowingly?
Well, I mean, I think you have to infer it from the situation, but I would suggest that if he's still there, that he probably doesn't know that he's not supposed to be there. At least that would
So
be.
your belief is everyone always listens to the police in every circumstance?
Oh, absolutely not. I went to Ohio State in the late 1990s. I saw a good share of riots, but did not participate in them. But, I mean, we can't assume that everyone is like me, and just like we can't assume that everyone who is there knows that they have to disperse. They called the state of emergency late in the evening on July 3rd, and this was a couple hours later. I mean, it's reasonable to believe that if he weren't in the location of the police when they made that announcement, that he might not know he's supposed to leave.
Was there any evidence he was in the area that the police were given warning earlier in the evening?
No. There was evidence that he had been throughout the city, but there was no evidence that he was ever in place at the time the police made an announcement. And I think that the Foster case from Cincinnati is a perfect example of this. There were this was in the 50s, I believe, there were 2 separate cars of persons who were arrested, and the court found that you just can't infer that knowledge, and they listed a variety of examples of, maybe they're deaf, maybe they just left a cloister, maybe they had just arrived to the city. And they specifically pointed out that if you're using the statute just to remove people without warning them, that you're just creating a de facto curfew, which is pretty much what happened here, because Captain Yohe specifically, who was monitoring the entire situation from the command post, specifically told all of the officers on the ground to just arrest anyone who was there. He specifically testified that he gave an order to arrest any loiterers. They were directed to arrest everyone that they encountered. They obviously didn't do that because they didn't think that they were a little outnumbered, they thought, but they do still have to have a valid reason to arrest him. And they charged him with failure to disperse based on the fact that there were 5 or more persons, but he was standing in the roadway with only 2 or 3 other people, which Sergeant Sinsley testified to multiple times. The state wants you to incorporate everyone who was downtown at that time into this group of people, but it's not isolated enough. he can't be held accountable for everyone else's conduct. And that's what the city is trying to enforce here. The people who were in the cars that he was walking were trying to leave the city. They were trying to get out of the situation. They were no longer participating in this riot or state of emergency. And to say that they were part of this problem, I think just expands the statute too much. Finally, the city didn't prove that he was engaged in disorderly conduct. There's 5 different ways that disorderly conduct can occur, and he was charged, and the jury was given instructions that he was engaging in fighting, threatening harm to persons or property, or in violent or turbulent behavior. And the city chose to charge him that way. They could have amended the complaint. He obviously wasn't fighting. There's not really evidence that he was threatening harm to persons or property if he was just standing in the road, and or that he was engaged in violent or turbulent behavior at the time. Just standing in the road is not, I would argue, violent or turbulent. I mean, there wasn't an option for the city to charge him with hindering or preventing the movement of persons on a public street. But they didn't charge him with that. The jury did not convict him of that. I think that's all I have about failure to disperse, unless you have any other further questions. So a couple days after...
You just did about 1.5 minutes in your initial time, just so you know.
Okay. So the other conviction is for driving within a single lane of traffic. A couple days later, Mr. Beasley was driving down the street in the left-hand lane of a 3-lane road, so, in the wrong direction. And he was charged with a marked lanes violation, which prohibits a car from leaving a lane of traffic that it's driving in unless it can do so safely. But there's no evidence that he did that. He could have been charged with driving on the wrong side of the road, but that's not what he was charged with. The evidence is that he was driving in the left-hand lane, and he departed it to pull over only after the police drove in front of him and he had to get over to the other side. So, again, if the city wanted to charge him with driving on the wrong side of the road, they could have. What they charged him with and took to trial is that he was leaving his lane of traffic while he was driving. But there's absolutely no evidence that occurred. They didn't present any dash cam video. There's no evidence of why he was driving on the left-hand side of the road. And there's no evidence about whether he was doing so for a safety reason, whether he left that lane of traffic for a safety reason. So I would argue that he can't be convicted. Finally, we have an argument about the other acts evidence, the video compilation, and the
Your
photo.
rebuttal time is, if you want to continue, you may, that's your decision.
I'll just take 1 minute.
Sure.
We would argue that the video is not relevant. The state might argue that they needed to play it because he was also charged with arson, of which he was acquitted. But they could have just taken that bit of the video. They're trying to impugn all of the actions of everyone who was downtown that day onto Mr. Beasley. And then there's also a bolo that was introduced. And the city argues, well, it doesn't mean it was bad. There could be another reason he was looking for him. But if that were the truth, then why wouldn't they say, well, we wanted to give him the Citizens of the Year award. That's why we were looking for him. I mean, it's pretty obvious to anyone that if there's a bolo, it's because he probably did something bad. And while the city says, well, Judge Kirk didn't necessarily need to consider that in the marked lanes violation, and maybe he didn't, the jury still heard about this evidence and knows that he was already being looked into by the police. So all of that we argue is inappropriate other acts evidence. And with that, I will take my time.
Good morning, and may it please the court, I'm Jack Woodett-Corrigan on behalf of the city of Akron and the state of Ohio. And I ask this court to affirm Mr. Beasley's minor misdemeanor convictions in this case because, first of all, the evidence that was presented in this case, not just the evidence that limited to the evidence that Mr. Beasley believes is the only thing that, or only evidence that is actually admissible in this case, but all of the evidence that was presented, that all of that evidence supports each element of the offenses and is therefore sufficient to justify his convictions, but also that all of the evidence that was offered was indeed properly admitted in this case. Now, concerning the sufficiency of the evidence, the state, because I'm discussing a state statute, I'm going to refer to the position of the city and the state as just the state. The state would remind the court that under the plain language of the statute that is involved here, there is no requirement that Mr. Beasley be committing disorderly conduct at the time that he was arrested. There's no requirement in the statute that the disorderly conduct had to be occurring at the same time as Mr. Beasley's arrest. There's also no requirement that an officer specifically direct an announcement that one must leave the vicinity to the defendant specifically. There's no requirement such as that. Instead, I would ask the court to consider the notes of the Legislative Service Commission that are part of the legislative history of this statute. When it was enacted, when it was passed in 1973 and enacted effective in 1974, that the statute was designed to, and I quote, furnish a simple, easily proved, and minor offense essential for the effective control of disorders. So it is designed to be simple and easily proved. And what the statute actually requires, the essential elements of the offense, as discussed not only in the plain language of the statute, but also in the Legislative Service Commission notes, is that first of all, there has to be a lawful order. And that has, whether there was a lawful order to disperse was disputed in the trial court below and has been disputed here in the Court of Appeals. What that requires to have a lawful order to disperse is that 5 or more people have to participate in disorderly conduct as described in Revised Code Section 291711. There's no requirement that it has to be, that the defendant has to be among those people committing the disorderly conduct. Also, there has to be other people present who are not committing disorderly conduct, but whose presence in the vicinity of the disorderly conduct, meaning the surrounding area, they have to, their presence has to create a likelihood of either physical harm to persons or property or serious public annoyance, which, as is noted in the Puzzle case, can be public annoyance, loud noise, also it includes alarm or public inconvenience as defined by as the statute says. Now, the state presented sufficient evidence on each one of these elements, and for sufficiency, that's all that's required. This is a burden, it is a burden of production issue, not a burden of persuasion issue. So alleged competing evidence does not factor into the sufficiency analysis. So what the state presented was that certainly there were more than 5 people engaging in a course of disorderly conduct, including Mr. Beasley, who was noted not only to be fanning the flames of the dumpster fire on video, seen doing that, but also there's testimony from officers that he was blocking traffic from leaving downtown at the time when, right before he was arrested. So we have officer testimony, we have video evidence of that. In addition, there's all the video evidence of other people participating in a course of disorderly conduct, breaking windows, turning over planters, all of that. But also the presence of others who are not participating in the course of disorderly conduct, and the state presented evidence of that. We have testimony, and again, the video evidence that there were many, many people downtown, and that the presence of those people downtown, blocking traffic, clogging up the streets, was at a minimum hindering the potential for firefighters, EMTs, ambulance drivers to get in and respond to emergencies, not only downtown, but potentially to get people who were experiencing emergencies elsewhere from being transported to at least 2 local hospitals.
So your position would be that all those folks who were there not engaged in disorderly conduct could have been charged with this offense?
They could have. Our testimony was, though, that even though the announcements to disperse were repeated over and over and over at multiple locations, that officers were not looking to arrest each and every person who was still downtown after they issued the order.
So you want us to look at this particular case as involving Mr. Beasley, that he would charge because he was in fact engaged in disorderly conduct earlier in the evening?
No, not necessarily. The reason was that when confronted by the SWAT team, as they went down South Main Street, around the Spaghetti Warehouse area, he was actually seen actively with other people blocking traffic, and the SWAT team made an announcement again and again and again as they approached that group, and so they did, contrary to the arguments here, they did actually give Mr. Beasley the order that you must disperse.
And at that time, there were more than 5 people in the area. The panel argues there's less than 5 people directly traffic. Do you concede that, or do you disagree that there were?
I disagree with counsel's interpretation of the statute. As some of the case law indicates, I think it's the Whistle case, this is not a static event in time, okay? The disorderly conduct does not have to be contemporaneous with the arrest. So that means that Mr. Beasley did not have to be in a group of 5 or more people blocking traffic at the time when he was told you must disperse, and he did not. The course of conduct of disorderly conduct with 5 or more people can happen before that, and clearly did in this case. So you don't have to have the police observing 5 or more people right here, right now, committing disorderly conduct, and a few other people milling around them, and only then may you give the order to disperse, and only then must you arrest somebody promptly, okay? That, in essence, is a reliance upon previous statutes that were inherent in the Foster case that counsel cites. The previous statutes that were repealed in 1968 when I was 2 require a proclamation to people immediately upon observance of the disorderly conduct. So what the legislature did when it enacted the current statute was to try to deal with situations which, at the time when it was enacted, were pretty fresh in their memories. After all, it would have covered, for instance, the 1970 protests at Kent State that led to students being killed and wounded. So it could have been used in that situation and was enacted to prevent that kind of situation from occurring. So under the view of the state, we have presented evidence sufficient that, if believed by a jury, would support the offense on each and every essential element of the offense, a failure to disperse, as it was actually written by the legislature and noted upon by the Legislative Service Commission, and then interpreted by State versus Kiss and Harker from the Kent State Kent Fest, and also Pussel from Oberlin College, which was a decision out of this court because Oberlin College is within this district. So again, it's not necessary for the disorderly conduct to be happening contemporaneously with the arrest. I would just very quickly move on for the court to the Mark Lane change. I just have a very brief comment on that. There is that second section to the Akron City Code, and so I'm going to refer to, the city presented sufficient evidence of that marked change or marked lane change violation. The other section requires that a person cannot travel in the center lane unless they're either passing or they're making a left turn. And the argument by counsel, as I understand it, is that Mr. Beasley had pulled over into the eastbound lanes of Talmadge Avenue from the westbound lanes in order for police to pull him over because police had gotten around his vehicle. Even though there wasn't a clear statement of we pulled around him to one side or the other of his vehicle, for his vehicle to have started in the westbound lanes, which was the far, from his perspective, the left lane, gone 2 to 2.5 blocks before police circled around his vehicle, to be pulled over and finally come to a stop in the rightmost lane, he had to have traveled in that center lane for a distance before the police moved around his car. If they had moved their cruiser around his vehicle on the right side of his car, they would have pulled him over in the left lane, not the right. So he had to have traveled at least some distance. And that was after the police had already set off their lights and sirens, and because he had traveled more than 2.5 blocks, they were believing that he was not going to obey them and stop, and that's why they made a maneuver to actually pull him out of his car and stop him. Next, very briefly, concerning the video evidence that has been challenged on the Bolo, I would remind the court that there really isn't a clear attack on this evidence as being other acts evidence. Or that under the ordinary evidentiary standard of review, this court could only overturn the decisions of the trial court if there's an abuse of discretion that affects the outcome of the proceeding. And an abuse of discretion, I would remind the court, is not just an ordinary error of law. It has to be something that evidences that the trial court abandoned a sensible reasoning process or a sound reasoning process, and that its decision essentially results from perversity of will such that no conscientious jurist would make the same decision. And without that, and as showing that it affected the outcome, this court will not substitute its judgment for that of the trial court and will sustain the decision. But one of the things that, concerning the video evidence is that if it's truly 404B, other acts evidence, there's a multi-step process to the analysis. It's not just merely an abuse of discretion, but there's multiple steps and multiple standards of review. But it actually has to be other acts evidence, not of other people, but of the defendant themselves. So unless it's other acts evidence by the defendant himself, it does not fall under 404B. The multi-step analysis of Hartman and Smith does not apply. And I would refer the court to Hartman and Smith and even to the plain language of 404. The prohibition, even back into the common law, against using a defendant's acts against him only bars the prosecution's use of the defendant's acts against the defendant to show that the defendant has a propensity to commit the act that the defendant is currently charged with. Not that other people have committed acts that would establish a propensity of this defendant to commit the acts with which he is charged. So I would refer the court to Smith and Hartman. The court wishes Smith, it's at paragraph 36, and Hartman, it's at paragraph 21. It is clearly just the defendant's acts. So saying these weren't even the acts of Mr. Beasley is actually fatal to an other acts evidence argument.
With that, counsel, note your time is up. You may briefly conclude.
Yes, I thank you very much for the court's time, and I would urge you on behalf of the city and the state to affirm. Thank you very much.
Commissioners, what the city repeatedly fails to realize is that it wasn't the crowd of protesters that were on trial, it was just Mr. Beasley. So it doesn't matter if the dispersal orders were yelled to these other people, it doesn't matter what they were doing. Their acts aren't even relevant to Mr. Beasley's case if he didn't commit them. And nobody disagrees that the city shouldn't be able to lawfully order people to disperse, but they have to do it lawfully. Here, I would argue, Judge Stevenson, that the earlier orders were followed if Mr. Beasley heard them, because he was on his way out of town with all these other cars and people who were leaving downtown. To conflate his earlier actions or the earlier actions of anyone else violates the concurrence principle. The statute specifically says that the things are happening, are participating, others are involved. That's a present tense, it's not a past tense. It doesn't matter if 2 hours ago he lit a dumpster on fire. It doesn't matter if he was driving around earlier in his car. The traffic was leaving and he was taking an affirmative act to go with them. If he had stopped in front of traffic, they could have charged him with disorderly conduct for blocking the road, but they chose to charge him with failure to disperse, which incorporates all these other elements that they failed to prove. If they wanted to convict him of disorderly conduct, they probably could have, because he was standing in the roadway blocking cars. But they chose to charge him with this different crime with additional elements, and then they didn't prove them. The marked lane violation smacks of entrapment if the only reason that he left the lane was because the police drove in front of him. There was no evidence that he left the lane or that he did so unsafely. We don't know if there was a crowd of protesters in the right lane that he was trying to protect from cross traffic. We don't know if there was construction there that blocked the lane. There's just no evidence.
I know your time is up, if you would conclude, please.
With that, thank you. We ask again that you reverse the judgment of the trial court and discharge Mr. Beasley on both counts. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is made, the clerk will mail a copy of that to you.